You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
I'm Cristina from CVG Solutions, a multi-award-winning data protection consultancy.
And I'm Michael Mulholland from Spencer West, a multi-jurisdictional and multi-partner law firm, and I specialise in data protection and AI regulation.
Now, Michael and I get together a few times a month to review and discuss legal cases that we think are interesting and that have a data protection angle to them. We do this as a way to expand our knowledge in data protection and its applicability to better advise and support our clients. Please share your thoughts in the comments and give us a thumb up.
Okay. So, Cristina, today we're going to discuss a statement of claim which has been submitted by the Good Law Project. So the Good Law Project take on pieces of, I guess, a campaigning law, and they're looking to, I suppose, counterbalance wealthy and big money and fight on the side of the individual or citizenship. And this is one such case. So this was around the UK political party reform. So the Good Law, in the background of it, is that the Good Law Project had created a tool which enabled hundreds of electors, part of the electorate, to make application to get a DSAR. And they sent in, so they empowered 13,000 individuals to go to different political parties and ask the political parties what data that they held on them. And the Reform Party didn't reply to hardly any of them at all.
Wow, that's shocking.
Yeah. So they didn't comply with the requests. So obviously we know that under Section 15 of the UK GDPR, you can make a request to see all your data under a data subject access request.
Yeah.
And the case is interesting is because the Good Law Project are looking to represent the body of the electorate under Article 80 of the UK GDPR. So they're saying that we're authorised to bring a legal action on behalf of data subjects regarding their subject access, their data protection rights that haven't been delivered. And because there's been a blanket ignoral of the actual requests, so it looks like Reform haven't complied with the time limits where they should be replying to those requests, which should be up to a month. So that's under Article 12.3.
Yeah.
And there's potential penalties, as we know that the GDPR, the UK GDPR, for severe violations can be 2% of global turnover, or up to fines up to 10 million. So, but it opens up a lot of interesting things. There's a lot of interesting stories there. So the nature of a DSAR, so with Reform as well, they're not that keen on regulation. They're looking to reduce regulation as part of their unique offering.
Yes.
But we know that Nigel Farage as well has a bit of a history regarding the UK GDPR.
Yeah.
And
also, I mean, sorry to interrupt you, Michael, but when you're talking about, so a political party such as Reform or Conservative, doesn't matter who they are, but they, in order to target their audience, if you want, they collect an awful lot of what is called special category data, don't they? They collect not only your name and potentially your address, but also obviously your political opinions, through social medias, through potentially other means, your religion, your ethnicity, your philosophical belief, potentially even trade union membership. And so all of that, is quite sort of sensitive data, and they're using it to then, target their marketing campaign in line with that. And so there's a lot of that data that they should then, from a subject access request, they should release it. Do you know what I mean? They should tell us what they've got.
No, I think that's probably part of the reason for the reluctance to provide that data, because you'll be able to find out where they got the data from. So there might be data scraping. You find what and who they've disclosed your data to. So you want to know and you want to know if they've actually got anything about you as well, if they do hold any data.
Yeah.
I mean, I first became aware of this during the Brexit campaign, going back many years now, probably a decade now. And I remember seeing lots of adverts targeted at myself and my former schoolmates on the Facebook, and it was this. And I thought, this is unusual type of targeting, and it was all St. George's Cross and all that sort of thing. And I knew this was something unusual, and it was like preparing people and looking at their responses so they could target for the Brexit referendum. And then subsequently, we know that the scandal came about with Cambridge Analytica.
Yes.
You could argue that the margin of victory in the Brexit campaign was slight, and then perhaps without this targeted campaign, the referendum might have gone the other way.
Yeah.
Well, while we're on the subject as well, there's an interesting decision last week where the investors of Meta litigated because Meta was fined $5 billion by the FTC, and the investors of Meta thought, well, why should we pocket that? We've not done the wrong here.
Yeah.
And there's an out-of-court settlement. But that related back to the Cambridge Analytica and the data that was provided under that in the presidential campaign for Trump. So the same thing that happened in the Brexit campaign happened in the US campaign.
Yes.
So really this is about the power of the DSAR. So it's being ignored at the minute, and Nigel Farage himself knows the power of the DSAR because he made an application, he made a subject access request to Coutts because he was denied a bank account, and he suspected that there was some sort of political reason behind this.
Yeah.
And then he made the application, he sent in the request, and lo and behold, there was opinions about his views and his political views, and then they looked at particular what risk might arise from having him as a customer, and is he the right type of customer they wanted for Coutts? And that led to the senior head's role in Chief Operations Officer and the Chief Executive Officer. And I remember it created a huge hoo-ha in the media at the time. So it just shows that the importance of the DSARs in finding out the detail about what these companies have on you.
Yes, because actually, the documentation then Nigel Farage was then presented with in terms of the data that the bank hold about him. It was about his like you say, their thoughts about the risk that he represented because of his stance on Brexit, on LGBTQ+, net zero policies, his comments on immigration. And so the comments, were about that that his personal views don't align with the values of the bank. And so they basically discriminated against him. So it's really interesting, the fact that he has used data protection, to his advantage to help him, but he's not prepared to do the same when, when he's the controller, when his party is the controller, and individuals are asking for the same data of him, so to a degree.
It's ironic, isn't it? Because the same issues that faced RBS and Coots is now facing reform. So it'd be interesting to see how it goes. And in the Farage DSAR case, the ICO did find that there was some breaching of his rights.
Yeah.
So this is it throws up a lot of issues, and it throws up a lot of history. But
it also goes to show that if you don't have robust processes and robust policies, it goes to show that it is the people at the top whose head is going to roll. So it's really important for any leaders, any sort of directors or CEO of any organizations or board of trustees in a case of charities, that you really need to own and understand the processes and hold people to follow the policies, including yourself, obviously, because otherwise you're the one who are accountable. And I find that in a lot of small businesses, that is not fully understood. So I don't know whether you come across the same, mindset, I suppose.
Well, I think, obviously this is in the context of the political field, and so we've spoken about the referendum and the fine, the FTC fine, and the investors case against Facebook. There's a book which I read maybe 4 or 5 years ago now by a guy, a journalist called Peter Gagan, and it was called Democracy for Sale. So it shows that you don't really need huge sums of money where you can target individuals and in order to sway elections. So I think his name was Nix, the guy who was the head of Cambridge Analytica, and they were sort of showing off about how they'd swayed presidential elections around the world. And Gagan calls data the most valuable commodity in politics. So this is why it must be touching a sensitive nerve with reform. But I wouldn't say that obviously they're not the only ones who may be doing this. It's the other parties will not be above this, and they get more sophisticated and realise how they know the importance of actually communicating and getting in touch with the voters, and then persuading them to your opinion. And then over time as well, if you keep repeating the same message, when you speak to people, sometimes they come back and they're like an echo board or an echo chamber. It's like, that's not even your own thoughts. You know it's not, because you're parroting the messages that are actually subliminally, though you're unconsciously absorbing. But but it isn't. The DSAR. This is the power of the DSAR. So it can reveal the methodology of the party, and then it also can lead to whichever party it is, and it can also lead to who's funding you and who's behind that. So Gagan calls it dark money. But it's big, powerful players, and we know even recently with Elon Musk, who's taken credit for manipulating the algorithms, and he owns X, formerly Twitter. So you can see that rich and powerful people are using the manipulative qualities of the algorithms.
I mean, they do say that data they do say that data is the new oil, and
it is. Yeah,
and it is.
And we can see that. So I think this one. So with this reform case, it's just watch this space. But I think it's going to have a lot of mileage, and there's going to be a lot of issues that are going to come out from this. And
so it's not gone to court yet.
What's gone in is the statement of claim,
Yeah.
And and then a defence has come out by reform. So under that, the section 80, the defence is actually you don't have reform. You don't have the right. It's not appropriate that you are acting as representative for these people. So they're trying to strike the claim out on those grounds. But that's just one. That's like a technical issue.
Yes.
But no. So I don't know. I don't know if any dates have come down the line for that, or whether maybe reform will try and deliver the DSARs. I don't know what's happened since then.
So someone is one to watch. Then we need to keep an eye on.
It's one to watch. Yeah, I had a look at the Good Law Project, the website this morning, and it doesn't seem to have moved on since that case, since the statement of claim went in. But there we are. So it's always fresh and relevant, isn't it?
Oh, that's really interesting. Yeah. So I really want to know, the outcome. So let's keep an eye on this case and see what the ruling is. That would really be interesting. Obviously this case it's against reform, but it could be any of the other parties. Because I'm pretty sure that all of them, to different degrees, they're all doing the same, more or less.
Well, as I said, it looks like they empowered 13,000 people to make subject access requests. So it must have been quite unusual that reform had replied to hardly any of the requests. So maybe that's probably why they maybe gone down the road for that. But we'll find out more in the future.
Yes. Well, Michael, thank you very much for sharing with us and with me, and always a pleasure to talk about case law with you. And see you next time.
See you next time. Thanks, Cristina.
All right. Just to remind everybody, if you would like to contribute to the discussion, please use the comments and give us a thumb up.